Hello, everyone, and thank you for joining us for today's webinar, Copyright Essentials for Visual Artists and Photographers. My name is Alicia Morris. I work in the Public Information Education Office, and I'm the host of today's webinar. Before we start, I'd like to share just a few logistical announcements with you. During today's webinar, you will be able to submit questions using the Q&A button at the bottom of your screen. We will answer these questions after the presentation is complete. However, we may not be able to answer all of the submitted questions. Furthermore, please note that since this session is being recorded, if you choose to participate and your question is addressed, it will be included in the recording as part of this webinar. And now I would like to welcome the Director of Public Information Education Office, Miriam Lord, to provide opening remarks. Hi, Miriam.
Thank you so much, Alicia. Well, hello, everyone. I'm delighted to welcome you all to today's webinar, Copyright Essentials for Visual Artists and Photographers. This is part of a 3-webinar series from the United States Copyright Office, where we demystify copyright law by creator discipline. Today, attorney advisors Jessica Chinnadurai and Laura Kaiser will be leading us through the webinar. One of the Copyright Office's key strategic goals is copyright for all, which to us means making the copyright system as understandable and accessible for as many people as possible. This new series is an essential step in that mission. Thank you to so many of you for joining us. We saw record registration numbers, almost 1,000 from all over the country and several other countries as well. So thank you all for joining us, and I'll pass it off to Jessica to take it from here. Thanks.
Thank you, Miriam, and good afternoon, everyone, and thank you so much for joining us. We are thrilled that so many people want to learn about copyright. And today's session is the first, as Miriam mentioned, in a 3-part series that we're hosting this year, where we will explain copyright as it's relevant to a few professions: visual art and photography, musicians, and writers. Before we get into our session, just a few more logistics for you. This event is being recorded and captions are enabled. Throughout today's webinar, we'll highlight a few resources, and associated links will be dropped into the chat throughout the program. There will also be a survey after the webinar that we would very much appreciate you complete, because we do develop programs like this with your feedback in mind. So as Miriam mentioned, today your presenters are myself, Jessica Chinnadurai, and my colleague, Laura Kaiser. We are both attorney advisors in the Public Information and Education Division of the Copyright Office, and we frequently participate in outreach projects like this webinar because we enjoy demystifying copyright and helping the broader public understand what it is. For a brief overview of today's webinar, we first have planned a high-level overview of the Copyright Office, and then we'll talk about the basics of copyright law before getting into some common questions that we hear from visual artists and photographers. We'll provide some considerations and important points to remember, and then we'll talk about copyright registration, including a few application options geared towards visual artists and photographers. In case you create different types of works and are just listening in because you're curious today, our future webinars for musicians and writers later this year will have a similar sort of setup, except geared towards those specific professions. And today you'll also hear directly from our colleague in the Public Information Office. We are always reminding audiences that you can contact staff with your copyright questions, but many of you might doubt whether they're actual people, so rest assured they are. And we want you to meet them and know that you can contact them anytime. Then we'll end by answering a few questions from the audience. So if you missed the announcement in the beginning, please do use the Q&A function to submit those. So first, let's start with some history of the Copyright Office. Laura, over to you.
Thank you, Jessica, and hello, everyone. The United States Copyright Office was founded in 1870, and we are a government agency that is part of the Library of Congress in Washington, D.C. So we are part of the legislative branch of government. And when we talk about the Copyright Office administering the Copyright Act, that's a broad statement and it entails a number of different roles. So let's look at the various ways the Copyright Office carries out its mission. The office has several important duties that help fulfill copyright's constitutional purpose. Our mission statement is to promote creativity and free expression by administering the nation's copyright laws and by providing impartial expert advice on copyright policy for the benefit of all. Our small but mighty staff of about 450 employees has many responsibilities. First, we make and maintain records that provide details on copyright ownership. which includes registration as well as recorded documents about transfers of ownership. We also administer statutory licenses and help manage and distribute royalties as required by law. Congress has also delegated authority to the office to develop regulations concerning many different areas of copyright law. And the subjects of those regulations cover a wide range of topics, including rules governing submissions to the office, such as different types of copyright applications, fees that are paid for the office's services, and filings related to statutory licenses, FOIA requests, and more. And these regulations provide the public with a well-functioning copyright system. Now, copyright law is found in Title 17 of the U.S. Code, also known as the Copyright Act. And the law states that copyright protects original works of authorship that are fixed in a tangible medium of expression. What this means is that first we must have a work of authorship, and that work must be fixed and original in order to be protected by copyright. We'll go over the work of authorship categories in more detail, but let me just take a moment here to explain what fixed and original mean. Fixed basically means that the expression must be written, recorded, or otherwise captured in a copy, and it must be sufficiently permanent or stable enough to be perceived, reproduced, or communicated for more than a transitory duration. The moment a work is fixed is the moment that copyright protection begins. Originality in copyright involves two components. The first is independent creation, and the second is sufficient creativity. Independent creation means that the work must be independently created by the author. So that means that the work needs to originate from the author and it can't be copied from another work. So in theory, you could have two works that could be the same or very similar, and they can each have copyright protection as long as those similarities are by chance and not the result of copying. Sufficient creativity requires that the work contain at least a small amount of creative expression, but that small amount needs to be more than trivial. So as we'll explain more later, things like words and short phrases, familiar symbols and designs are not protected by copyright. The term work of authorship means the subject matter protected by copyright. So these broad categories include the following: literary works, for example, poetry or computer programs; musical works, including any accompanying lyrics; dramatic works like plays and operas; pantomimes and choreography; pictorial, graphic, and sculptural works, for example, fine and graphic art, including maps; wallpaper designs, even something like stained glass windows would be included in this category; motion pictures and other audiovisual works, for example, video games or virtual reality environments; sound recordings like audiobooks and podcasts; and architectural works, for example, museums and pavilions. Our focus today is visual artists and photographers. So the work of authorship categories that apply are architectural works and pictorial, graphic, and sculptural works. Architectural works can be registered if they are habitable structures that are stationary, that is, they're intended to be permanent, and they're intended for human occupancy. And copyright protects the overall form and the arrangement and composition of spaces and elements in the design. And returning briefly to our requirement of fixation, architectural works can be fixed in the buildings themselves, in the architectural plans, or in drawings. Now, most of this presentation is going to cover graphic art and photography, so if you'd like to learn more about registration of architectural works, we encourage you to check out Circular 41, and we'll put the link to that circular in the chat. The office's circulars cover basic concepts of copyright law and the registration issues for specific categories of works. Pictorial, graphic, and sculptural works, it's a pretty broad category, so let's look a little bit more closely at what that includes. In copyright law, we have the definition on the left, which is a list of what's included in the pictorial, graphic, and sculptural work category. You'll notice it includes a wide range of works, some of which might be familiar, like paintings and photographs, but it could also include works that you haven't thought of. For example, things like puppets or stuffed animals could be registered as sculptural works, and prints include everything from stationery to advertising materials. Even edible materials, think of something like molded chocolate. Maybe you received some from a loved one last week. That could be a visual artwork as well, and it could be protected by copyright as long as it's original. So it has to reach that threshold of sufficient creativity that we discussed earlier. And with that, I'm going to kick it over to Jessica to get us started with some common industry questions.
Thanks for that great background, Laura. And with some basics in mind, I think we can dive into some of the questions that you might have asked yourself about copyright as either a visual artist or a photographer. Before we begin, we just have a couple of important notes. First, being the US Copyright Office, we wanted to note that the images we've included as examples to illustrate concepts today are being used with permission from the copyright owner or are licensed from Shutterstock. And second, the office knows and understands that there are many questions and topics to address, too many, in fact, we think for a 1-hour webinar. But what we've done is simply compile the most frequently asked questions with the objective to help explain some considerations to keep in mind and points to remember when it comes to visual artwork and photography. So starting with this first question, we often hear, which basically asks us to consider the subject matter of a photograph. The question might sound like, if I take a picture of the Capitol building, doesn't the government own my photograph? And some underlying questions here may sound like, well, how does the fact that the building is owned by the government play into copyright ownership? And if I take a picture of the Capitol building, what happens if someone takes a similar photograph of the same building? Those are all great questions, and we've got a couple of important considerations to help us get started here. First is that an author of a photograph is the person who presses the capture button, or in other words, the photographer. And that photographer is the initial copyright owner as well. So returning to our question, doesn't the government own my photograph because the building is federal property? The answer is no, unless the photographer, otherwise known as the initial author and copyright owner, has transferred their copyright ownership in the photograph to another person or maybe to a business. They remain the copyright owner. The subject matter, meaning the focal point of their photograph, does not change this fact. It's also important to consider what it means to have an original photograph. Creativity in a photograph reflects the photographer's artistic choices in creating the image, such as the selection of the subject matter, the lighting, any positioning of subjects, the selection of camera lens, the placement of the camera, the angle of the image, and the timing of the image as well. So regarding that underlying question of how it's possible that two people might take a photograph of the same building, yet both images are protectable by copyright, let's look at the example here on the screen. We have two photographs of the Capitol building in Washington, D.C. It looks like it might be, sunset in the top image, and the photographer is maybe standing closer to the building, so we don't see any lampposts or trees on the side. And in the bottom photograph, maybe this was taken at night and the photographer is standing closer to the sidewalk, away from the building. Maybe they even knelt down to take this image, so the angle is a little different. You can see, though, how similar these images are, but each is protectable by copyright despite the similarities. And that means that even if some photographs are remarkably similar in perspective, they can each be copyrightable in their own regard because the photographer selected the angle and position of the subject and made those other creative choices we talked about. So here's the first kind of takeaway point to remember for our photographers listening. A photograph may be protectable by copyright even if the subject matter is a scene, animal, building, or other item that isn't itself copyrightable. So what does that mean? Well, on the one hand, you may take a photograph of something like artwork, sculptures, or even a book, and those materials might be protectable by copyright. On the other hand, you might take a photograph of your dog, but your dog isn't itself copyrightable. Dogs don't fall under one of the categories that Laura mentioned earlier. So even so, the photograph of your dog is protectable by copyright. It all boils down to copyright in a photograph, not depending on the subject matter of the photograph. Now, a follow-up question that we get here is, what about a photograph of a celebrity or other well-known person? And the same principle still applies. The person who took the photograph is the author and the initial owner under copyright law in the United States. And other areas of law, particularly rights of privacy and publicity, may restrict how the image is used commercially. But a photograph taken of someone doesn't mean the person in the photograph automatically becomes the owner. Maybe a more relatable example is if you go on a vacation with your family, maybe to the beach, you ask a stranger to take your photograph. Even if it's on your phone, it was your phone that was used, The person who pressed the capture button is still the photographer and therefore the initial author and owner. None of the people pictured in the image are the photographer or the initial owner because copyright in a photograph, again, does not depend on its subject matter. Building in complexity just a little bit and moving away from photography, let's focus on logos. If you own a business, you've likely given it a name, and you may also have a slogan. So what happens if you incorporate both into a logo along with some artwork, and then you receive a trademark registration from a different government agency, namely the US Patent and Trademark Office? You might be asking yourself, is my logo automatically copyrightable because it received a trademark registration? The answer here is no as well. Just because your logo received a trademark registration does not mean that it's automatically protected by copyright or even registrable with the US Copyright Office. Taking a look at some copyright considerations that are relevant for logos, I'll start first with the fact that names, your own name, your business name, singular words, and short phrases are not protected by copyright. This is the case even if the word or short phrase is novel or distinctive or a play on words. So for business owners, this may include your catchphrase, your motto, or a slogan. Similarly, from a design standpoint, geometric or basic shapes, familiar symbols and designs, and color in and of itself are not protected by copyright. To expand on those last two categories, familiar designs might include arrows, stars, and hearts, or common patterns like polka dots or checkerboards. And with color, it's actually referenced in the law as mere variations of coloring, which just means that if an artist merely changes a few colors from work to work, that's not going to be enough for that sufficient creativity requirement for copyright protection. An example of this might be someone making greeting cards with visual and textual content. And if the only difference is that the card is printed in a different color, then not every card will be protected by copyright. This discussion of color here helps us understand a bigger consideration with copyright. And I'm sure I don't need to tell all of our visual artists listening in just how crucial color is in visual artwork. And this is where I think it becomes maybe easier to connect the dots about the purpose of copyright. All of the things I've just talked about are what we refer to as the building blocks of creativity. If artists like you don't have access to them because they are all under copyright protection, that would most certainly stifle creativity. And that's really the opposite of what we want. The purpose of copyright in the Constitution to incentivize creators is at the core of the office's mission. So moving to our takeaways for these questions related to logos, some key points to remember are first, copyright law is different than trademark law. Unlike trademark law, copyright law is not concerned with consumer confusion because the foundational principle in copyright law is originality, which includes evaluating whether or not artwork is sufficiently creative. If your logo includes a business name or your own name, or if you're relying on things like spatial placement, color, borders, or different sized fonts, those aspects are not protected by copyright, which is what copyright law tells us. Similarly, while trademark law might consider a logo's distinctiveness, copyright does not consider the commercial success of a work or how marketable it is or might be. Artwork might experience commercial success and still be lacking originality in terms of copyright, and vice versa. Artwork that is original might not enjoy commercial success. And the second point to remember here is that because copyright law is different than trademark law, trademark registration is a separate process from copyright registration. A trademark registration has no bearing on copyright registration, and practically speaking, what that means is that if you apply for copyright registration of your logo, the office will not consider whether the logo has been or can be registered with the US Patent and Trademark Office. All right, so we've wrapped up 2 questions for visual artists and photographers, and Laura is going to take us just through a few more here.
Thanks, Jessica. So another scenario that might be familiar to artists is the application of their work to everyday objects. What role does copyright play in those situations? So, for example, maybe you copied your photograph or your artwork onto a mug or printed it on a t-shirt. How does that affect its copyrightability? There are a couple of different considerations here. First of all, an object like a t-shirt, a mug, or a lamp is considered a useful article in copyright law. And a useful article is an object that has an intrinsic utilitarian function. So the function is not merely to portray the appearance of the article or to convey information. Now, obviously, there are many different items that could fall into this category, including kitchen utensils, tableware, vehicles, and lighting fixtures. These objects in and of themselves are not protected by copyright. However, if there are pictorial, graphic, or sculptural features of the design, those could be eligible for copyright protection if the features can be identified separately from and can exist independently from the object. The design feature has to also meet that low bar of creativity we discussed. So to illustrate the concept of separating graphic and sculptural features, take a look at the lamp pictured here. We can easily imagine the dog aviator as a separate sculpture. It can stand independently from the lamp, and in this case, as a decoration perhaps. And the dog aviator is not intrinsically useful on its own, and that's still true even if it could potentially be used functionally. For example, if it's used to hide electrical wiring or support the lampshade. So if you own the copyright in a photograph or another artwork, you have the right to copy that work onto a useful article, and that photo or artwork is still protected by copyright, even if it appears on a mug rather than hanging in a frame on a wall. The key here is to remember that designs on useful articles, whether they're 2 or 3-dimensional, could be protected by copyright as long as they can be identified separately from the parts of the object that are purely functional. This analysis can get a bit complicated, so if you'd like to read more, we suggest checking out the Compendium of U.S. Copyright Office Practices. The compendium is an administrative manual that explains technical requirements and legal interpretations affecting copyright registration to copyright applicants, practitioners, scholars, the courts, and the public. And the section on useful articles is found in Chapter 900, and we're providing the link in the chat. So with that, let's take another look at a common industry question. How does copyright law affect my ability to use a photograph as an artistic reference? Since the current copyright law was passed in 1976, it's become much easier for artists to search for and find images to use as inspiration or reference when they're creating their own work. So what copyright considerations should we keep in mind when utilizing other works in this way? Our first step here is to understand how copyright law defines what you are creating when you use a photograph as a reference. A painting, sculpture, or art reproduction that recasts, transforms, or adapts an existing work, like a photograph, is considered a derivative work. The right to create derivative works is one of the 6 exclusive rights that copyright owners hold. So the copyright owner has the right to create derivative works and the right to authorize others to do so. Let's take a look at this example. We have a photograph of a happy dog and a painting based on that photograph. The painting has taken the original posture, head tilt, smile, and fashion choices of our pup, including the red collar and the Cardinals jersey, and adapted it into a painting. In this case, the photographer and the painter are the same person, and as the author and copyright owner of the photograph, they have the right to recast the photo as a painting. If you don't have the copyright owner's permission and you create a derivative work, you could be violating their copyright unless an exemption applies. And because each situation is unique, you may want to ask a lawyer for guidance. And speaking of asking for permission, we are often asked by copyright owners about posting their visual art or photos online and how to communicate through captions or watermarks that they own the work and that they're requiring others to ask their permission before copying or reposting. One mechanism that copyright law addresses for this purpose is copyright notice. You all might be familiar with the C in a circle symbol, but copyright notice is more than just that symbol. It actually has 3 elements, including the C in a circle, the year the work was first published, and the name of the copyright owner. And even though adding copyright notice is optional for works today, one benefit is that potential users are then aware that the owner is claiming copyright in the work. I'll turn it back over to Jessica now for our final industry question.
Thanks, Laura. So we'll end our commonly asked questions here on a recent development at the Copyright Office and how it pertains to both visual artists and photographers. The Copyright Claims Board, or the CCB, is a small claims tribunal within the office, but how exactly can it be a resource for you? Starting with what the CCB is, it opened its doors in 2022, and it's intended to be a streamlined alternative to federal court to resolve copyright disputes involving claims up to $30,000. The CCB is able to hear 3 types of copyright disputes, one of which is copyright infringement claims. Copyright infringement of your artwork, sculpture, or photograph occurs when your work is copied, distributed, publicly displayed, or made into a derivative work without your permission as the copyright owner, and if the use does not qualify for an exception, such as fair use. Another type of claim that the CCB can hear is a declaration of non-infringement, which can be filed by a party accused of infringement. This could be useful if a party is worried about continuing a project, maybe under the threat of litigation, and they want to clarify or want clarity about the validity of the copyright owner's rights or the application of an exception. As I mentioned, the CCB is designed to be less expensive and faster than bringing a case in federal court. So in terms of how it can be less expensive, CCB proceedings are virtual, so they don't require you to travel here to Washington, D.C. They are designed to be clearly understood and usable by anyone, even without legal training. So users of the CCB are permitted to have an attorney, but can also represent themselves. As for how it can be faster than federal court, participants in CCB proceedings are only required to provide limited basic documents and information, as opposed to the more complicated process of exchanging evidence in federal lawsuits. CCB proceedings do not include the formal motions used in federal court, and again, any hearings are held remotely through video conferences. So 2 takeaway points to remember on the CCB. First, the CCB is for creators and users of photography, music, writing, visual art, graphic design, and more. If you work, create, or have a business in any of those areas or industries, then the CCB is absolutely a forum you can use to resolve a dispute, particularly if your work is used unlawfully and without your permission, or if you have been accused of infringing someone else's work. The CCB provides cumulative statistics to focus on key metrics, showing just how the CCB has progressed since its launch. And looking at the data covering the period from June 2022 to September 2024, 39% of the 989 claims filed were involving pictorial, graphic, or sculptural works, which means that this is an increasingly relevant forum for many of our listeners today in the visual art or photography industries. More comprehensive information about CCB operations and its history is available on the CCB website at ccb.gov. The link for that is in the chat now. And at this point, we're going to switch gears just a little bit to talk about copyright registration, which is, of course, one of the services that the office provides. Laura, back over to you.
Thanks. So yeah, as Jessica mentioned, we're going to take just a few minutes to talk about registration. So even though copyright protection is automatic and begins the moment the work is fixed, there are many important benefits when you register your work with our office. And remember, the Copyright Office is the sole administrator of the registration system in the United States. So one benefit is that registration creates a public record that includes key facts about the work that's registered. And that includes the name of the author, the owner of the work, the title, the year the work was created, the year it was published, and the date and nation of first publication. And along those same lines, the registration record may also provide the name and contact information for the person or organization who can field requests from those seeking permission to use the work. Importantly, registration is also a required component if you find yourself in a copyright dispute and you'd like to access federal court or the Copyright Claims Board. That means that if a work is infringed, it must be registered with the U.S. Copyright Office, or the office must have refused registration in order to file a copyright infringement lawsuit. And if you file a claim with the Copyright Claims Board, you have to have a registration from the Copyright Office for the work at issue, or you have to have submitted an application to register the work either before or at the same time that you submit your claim. Registration with the office is an easy process. There are 3 basic requirements: a completed application, the filing fee, and a deposit for each work that you want to register. An application is a form that gathers details about the copyright owner and the work, like the name and address of the copyright owner, the year of creation, and the title of the work. We'll go over fees in just a moment, but generally the cost varies depending on how many works you are registering and what type of works they are. And finally, the office examines a deposit copy. The deposit copy is a physical or digital copy of the work. With these benefits and requirements in mind, I'll take just a minute to explain a little bit more about timing and cost. On average, registration applications submitted online are processed in about 6 weeks, when no communication between our registration team and the applicant was needed. And that's what no correspondence means here on the slide. And when the office does need to communicate with the applicant, the average time to process increases just slightly to about under 3 months. In terms of cost, that depends on the number and types of works you're trying to register. The general rule is that you must submit 1 work with 1 application, and our most inexpensive form there is $45. However, the office has also created a number of group registration options that allow you to submit more than 1 work on 1 application, making the process more efficient and cost-effective. Most of the group options are required to be submitted online, and those applications range in cost from about $55 to $95. We'll drop the link to our registration homepage for your future reference, and there's a link on this slide as well, and we'll drop one in the chat for more information about our fees in our circular number form specifically. And I'll give the mic now back to Jessica to take us through a couple of those group options.
Great. So as Laura just discussed, the general rule for registration is to submit 1 application, filing fee, and deposit or copy of your work for each work that you want to register. However, the office has established a number of group registration options which can be used to register multiple works. Each group option has its own eligibility requirements, so you will always want to check those out before you apply. But first, taking a look at an application option for our visual artists, this is the group registration of unpublished works, or GRU for short. This is a great way to register up to 10 unpublished artworks, such as drawings, illustrations, and the like. The application has an $85 fee, and for each work that you intend to register, you must submit a copy of that work. And as the slide notes, all works must be in the same class. So for today's audience, we're likely talking about works of the visual arts, including pictorial, graphic, and sculptural works. Those all have to be submitted on 1 GRU, but the GRU is available for other types of works as well. And lastly, you must meet the GRU's eligibility requirements in order to apply. There are several, and we won't go over all of them today, but one important requirement is that all works must be unpublished. A work is unpublished if copies have not been distributed to the public for further distribution, sale, rental, leasing, or lending, or if copies have not been offered to a group for further distribution, public performance, or public display. Copyright law defines publication very specifically, so if you're unsure about whether or not your work is unpublished, or if you want to learn more about this application option, the office does have a dedicated webpage with additional resources, including a GRU circular, frequently asked questions, and more. So we will share that link in the chat now. Next, for our photographers, the office has 2 relevant options that we wanted to highlight today: the group registration of unpublished photographs, or GRUPH for short, and the group registration of published photographs, or GRPPH. With these options, photographers can submit up to 750 photographs on 1 application for a $55 fee, and you must submit only unpublished photographs on the GRUPH and only published photographs on the GRPPH. In other words, a group registration cannot contain both a mixture of unpublished and published photographs. And lastly, as with the last option, you must meet all of the eligibility requirements for each application in order to apply. There are several, and again, we won't cover all of them today, but you might have noticed again that distinction between published and unpublished. So one additional eligibility requirement, for example, to use the published photographs option is that all of the photographs must be published within the same calendar year. If you're unsure about whether or not your photograph is published, or if you want to learn more about these options, the office does have a dedicated circular covering more information, and that's linked to in the chat now as well. All right, so we just spent quite a bit of time going through registration basics, group registration options for visual artists and photographers, and commonly asked questions. We covered a lot of details. We understand it's a lot of information to digest, and you might be asking yourself, what should I do if I don't know how to get started or can't seem to find answers to my copyright questions? Well, look no further. The Public Information Office can provide a very practical pathway to your success, and they do it all with a smile. In fact, we have a colleague from the Public Information Office, Monica Beach, who is joining us today to tell us more about the work that she and her colleagues do every day. In just a minute, Monica will explain some services that we offer, but before we begin, please do keep in mind that staff of the Copyright Office cannot provide specific legal advice. Areas of inquiry that might involve legal advice, including assessing whether the use of a work is fair use, drafting or interpreting contract terms, evaluating publication status, weighing registration options, or providing an opinion on alleged copyright infringement. Now that you know that, we do want to ensure that you are aware of what the office can provide. So Monica, thank you so much for joining us. Can you please take a little bit of time to introduce yourself and tell us a little bit about who you are?
Yes, thank you, Jessica. Good afternoon, everyone, and welcome all of the creative and curious authors that are tuned in today. My name is Monica. I am a senior copyright specialist with the U.S. Copyright Office. I've been with the U.S. Copyright Office since 1988 and have worked in various roles over the years. Just to share a little more about myself, I enjoy creating new memories daily. For the photographers listening in, you may be interested in knowing that I too am a beginner in photography and love the creativity that I capture behind my lens.
That's great. Thank you, Monica. So let's dive into it. Can you tell us a little bit more about the Public Information Office and what you and your colleagues do every day?
Sure. The Public Information Office, or PIO for short, is central to the Copyright Office mission and outreach goals. PIO is a team of approximately 20 subject matter experts responsible for responding to thousands of inquiries each year from members of the public in the United States and around the world. As a senior copyright specialist here in PIO, I greet and assist members of the public with questions about copyright law, registration processes, and the benefits of registration. I also provide walkthrough assistance. My colleagues and I provide these services by telephone, email, and in person when people visit the office in Washington, D.C. What I enjoy most about my job is witnessing all of the creative talents and creative authors of various ages, in addition to educating and assisting various audiences with the application process for copyright registration.
Thank you, Monica. And I know people are super appreciative of that service that you provide. So let's take a closer look at some of the specific services that PIO provides, starting with a walkthrough. For those who might be unfamiliar, can you describe this service?
Sure. PIO can provide walkthrough services between business hours over the phone to help you complete your registration application during a 30-minute appointment. Our business hours are between 8:30 a.m. and 5 p.m. Eastern Time, so the last appointment can be scheduled for before 4:30. During a walkthrough, a staff member will assist you with navigating an electronic registration application by explaining the application screens and the types of information required. The office can provide you with information to help you reach decisions about how to answer application questions, but we cannot provide you with any legal advice. To request a phone walkthrough, you must request an appointment at the link being provided in the chat. When requesting a walkthrough, it is imperative to follow the directions and steps to confirm your scheduled appointment. Once you have submitted your request for walkthrough assistance, your form will be considered tentative until a staff member corresponds with you to confirm your appointment. If you do not reply to your confirmation email by 5 p.m. Eastern Time the day before, you will not receive walkthrough assistance. You would then need to complete another appointment request using the online form. Additionally, before your appointment, you must set up an account in the Electronic Copyright Office Registration System, also known as ECO. And you will need to have your ECO username and password ready at the time of your appointment. If you haven't taken these steps, you will need to reschedule your appointment.
Thank you, Monica. So you just discussed how walkthroughs are provided over the phone, but what about if someone wants to visit the office in Washington, D.C. to obtain any type of assistance?
The office welcomes visitors to PIO in the James Madison Building in Washington, D.C. We are open Monday through Friday, 8:30 a.m. to 5 p.m. Eastern Time, and we are closed on weekends and federal holidays. You can request an appointment at the link being provided in the chat now, or you may also walk in during normal business hours. Please note, as with our phone walkthroughs, the last on-site walkthrough we can provide is at 4:30 on-site. There are several services we provide in person. For example, walkthroughs can be requested on-site using our kiosk. If you do not schedule an on-site visit for a walkthrough ahead of time, however, please note that this service will be provided on a first-come, first-served basis between scheduled appointments. That's also the general rule for walk-ins. When visiting the office, you can also request certified copies of registration certificates and deposits, which is another name for the copy of your work that you must submit with the registration application. And lastly, members of the public can request for a search of the office records. This is a service often used by people who are interested in investigating whether a work is under copyright protection, and if so, the facts of the copyright. For example, the copyright owner's name. For a fee, the office will search its public records and provide a report of its findings. There's also a lot of information you can find online at the link we're adding in the chat.
Wonderful. So you just described some of the critical work that PIO does, and I know our audience is very grateful. But what else do you think they should know about PIO? Any closing remarks for us here, Monica?
All of PIO staff speak English, and we also have a few specialists on the team who are able to assist you in Spanish over the phone or email. You may request assistance from a Spanish-speaking specialist by sending a request to the email address on the screen, or by request to the email, or by submitting a request using the form at the link being provided in the chat. Additionally, the office has informational resources available in Spanish, including circulars, handouts, and FAQs. Lastly, remember that the Public Information Office is ready and eager to help you. So please get in touch with us today if you have any questions about copyright or want to learn more about the services we provide. Thank you for joining today's webinar, and we look forward to hearing from you. With that, I'll pass the mic back to Jessica and Laura.
Great. Thank you so much, Monica. It's always great to hear about the services that your team, PIO, provides to the public. And with that, we are now happy to take a few questions from our audience. And Tetro, one of our public affairs specialists, will be helping with the Q&A today. So over to you, Anne, for our first question.
Thank you so much. Thank you for all your questions. And just to let you know, this link for Circular 42 is now in the chat. Also, if we're not able to address your questions in the time provided, please do refer to those resources. Laura, I do have just a question, just as a reminder. You mentioned that there will be other copyright essential webinars. What will those cover again, and how can we find out about them? Also, when will this recording be available?
Sure. So the recording will be available in the coming weeks, so definitely stay tuned for that. And in terms of future copyright essentials, we will do a session for musicians and one for literary authors as well. So stay tuned for more updates and announcements about the dates of those. You can stay up to date by subscribing to our Newsnet, and you'll receive the notification.
Thank you. Jessica, we had several questions from photographers, such as, do I have to register all of my photographs? Should I register photographs before or after I touch them up? Could you address those?
Yeah, thanks, Anne. So first, let's start with just a point to remember that registration with the Copyright Office is optional. Your photograph, has copyright protection from the moment that you captured it. But that being said, we do realize that photographers might be taking thousands of photographs when out on a shoot. And so just keep in mind the group registration options that I mentioned earlier are limited to submitting 750 at a time. Now, it's your choice whether to register all of your photographs, and kind of weighing the risks of registering or not registering is something that the office cannot assist you with. You will have to ask a copyright lawyer for assistance with that. Again, the Copyright Office can't provide legal advice. But on the question of, should I register a photograph before or after editing, that kind of depends on whether you're making copyrightable changes to the photograph. For example, if you submit an unedited version, first and then later edit it, some examples of alterations that might warrant a new registration include like recreating missing parts of an image or using airbrushing techniques to change the image completely. But in contrast, something that's uncopyrightable is going to be, maybe changing the balance, the colors, the tint, and tone, or even sharpening of blurry images. In those cases, then a new registration isn't necessary. Hopefully that helps. Back to you, Anne.
Thank you. Laura, this question is for you. If I post my artwork on my social media account or website, does that mean the artwork is published?
Yeah, that's a great question. So the answer is not necessarily. So just because a work is posted or uploaded on social media or a website, it doesn't necessarily automatically mean it's published as the term is defined in copyright law. The term published has a really specific meaning in copyright. It's a distribution of copies of a work to the public by sale, transfer of ownership, rental, lease, or lending, or the offer to distribute the copies for further distribution, public performance, or public display. So it has legal implications for copyright protected works, and it does also affect the way that the works can be registered with our office. The compendium, that's that administrative manual I was mentioning before, reinforces that public display of the artwork doesn't in and of itself mean that it's published. An important consideration that the compendium points out is whether there's an express or an implied authorization on a website or social media to say download, save, or email the image, whether there's one of those buttons available. And if there is, it could be considered published, but the copyright owner's authorization is also required. So work isn't published unless the copyright owner authorizes it. So whether publication occurs online, it depends, as you can tell, on a number of additional facts. I hope that gives you a little bit of an idea of what to consider, though, when posting a work online. And back over to you, Anne, for the next question.
Thank you. This question is for you, Jessica. I'm a graphic designer who creates websites. What should I know about copyright and website design?
Yeah, that's a good question. I think it sheds some light too on the copyrightable categories that we talked about at the beginning of today's webinar. And you might have noticed website isn't something that's exactly listed in the law, but the office does consider a website to be, a web page by itself or a set of interconnected web pages. Technically by itself, again, it doesn't fall under one of the categories of copyrightable subject matter. But that being said, website content, such as literary or visual artworks that are displayed on a website, so maybe things like your articles, blog posts, photographs, and even music and videos, are all protectable materials. And then the way too that the website content might be selected, coordinated, or even arranged, either on one web page or on the website as a whole, might also be something to consider as copyrightable. And that's what we call compilation authorship. I'm not sure if we'll have the chance to link to it, but there is a circular that covers websites and website content. That's Circular 66. So you can access that on our website for more information.
Great, thank you. Laura, for you, I made a collage out of someone else's photographs and artwork. Am I the copyright owner?
Thanks, Dan. Yeah, another great question, and it actually picks up a little bit on what Jessica was just discussing with websites and website content. So again, in this scenario, a collage, we are talking about a compilation, which is a collection of existing material that's, as Jessica mentioned, selected, coordinated, and arranged in a way that the whole work is considered original and can be copyrightable. So you might be the author of that original arrangement of photographs and artwork, but that doesn't mean that you're the owner of someone else's photographs and artwork that you're arranging. So for registration purposes, the office actually instructs applicants to exclude someone else's artwork from the claim. But yes, we definitely recommend checking out the website and website content circular. They'll give you a little bit more of an idea of compilation authorship, and I hope that helps clarify a bit.
Yes, thank you. So Jessica, a lot of questions kind of circled around AI. So one was, how does the office treat original works, such as photographic works that may be enhanced by AI?
Sure. So the Copyright has an ongoing initiative related to artificial intelligence. More information can be found at copyright.gov/AI. The office continues to look into issues related or at the intersection of copyright and artificial intelligence, with our most recent part of our report covering copyrightability, the question of, what is copyrightable, and the office's stance has always been that human authorship is at the core of copyright. And so if a machine has just created something entirely or done the editing entirely, then that's not going to have or gain copyright protection. But if there is human authorship there, and then the use of a generative AI technology has been involved or included in the creative process, that's okay. It just needs to be disclaimed if a copyright registration is being submitted for that work. So I do encourage you to check out our report, part 2 of the report, which covers copyrightability, on our website, and then also just stay tuned for additional updates on artificial intelligence. It is an ongoing, interesting topic that the office does continue to consider.
Thank you. Laura, so if an artist is commissioned to create a logo for someone else, or how do you know who owns the copyright of that artwork, of the actual graphic design?
Yeah, it's a great question. So generally, we say that the person who created the work, who created the logo in this case, created the artwork, is the author, and they would be the copyright owner. But copyright law does take into account that exact scenario when somebody is commissioned. So there's another category that's called works made for hire. And there's a couple of different ways that you could have a work made for hire. And in that case, an employer or the person who commissioned the work could actually be considered the author and copyright owner of whatever was created. If we have a chance, we can link to our circular that covers works made for hire in more detail. There's a really helpful questionnaire in there that you can kind of go through and answer the questions. And at the end, you should understand a little bit more about whether you have a work made for hire. It is somewhat fact specific. There's a couple of different ways it can come about if you're an employee-employer relationship, and there's a number of factors to consider there, or if there's a written agreement that has all of the required components. It could be a work made for hire situation. But yeah, another plug for our circulars page, of course, that go over some of these details and nuances of copyright law in plain language for our audience. Thanks.
Thank you. And I think we have time for one more question. So Jessica, this one is for you. So for our jewelry designers, I designed a necklace. How do I know if it's copyrightable?
Yeah, great question. We didn't talk too much about jewelry today, but in general, Jewelry is absolutely a type of visual artwork. It's typically going to be protected under US copyright law as a sculptural work. And whether or not a jewelry design is copyrightable does depend on whether it's original. So again, we're talking about whether it's independently created and then sufficiently creative. So just to give our audience a sense for that second portion of originality, sufficient creativity. When we talk about jewelry designs made up of only commonplace elements won't satisfy that requirement. And what we're talking about there could mean something like a solitaire ring or even simple hoop earrings. We did link to the compendium chapter earlier on visual artworks. And so good plug there to mention that jewelry is actually covered in a little bit more detail in the compendium. Anne, did you mention that that was our last question?
Yes,
Great.
thank you.
Thank you so much for leading us through the Q&A. We appreciate it. And thank you all so much for your questions today and your interest in today's webinar. Before we end, the office does have many resources available to help you learn more about copyright, including those circulars that we talked about. And then there are also learning engine videos on YouTube. We also have the Copyright Public Records System. And of course, you heard today from our Public Information Office colleagues, so you can always give them a call or send them an email if you're interested or have questions. There is another resource that we wanted to just pay particular attention to today before you leave, which is our Engage Your Creativity web pages. The one today is pictured on the laptop here on the slide. So we do have dedicated web pages for specific professions, and the one shown here is what visual and graphic artists should know about copyright. This does provide specific resources for graphic artists, and we have a similar page for what photographers should know about copyright as well. So we're going to provide the link to both of those in the chat now. And then lastly, for updates from the office, you can also subscribe to our Newsnet, which is our digital newsletter. We do have a blog, other events and legislative developments that are happening, and that those subscriptions can be found at the link in the chat as well. And then finally, we do encourage you to follow us on social media, on X and LinkedIn, where we post announcements and relevant information. And with that, thank you all so much for attending today's webinar. A survey will be sent out to attendees, and we welcome and appreciate your feedback on today's event. Thank you and have a great day.